Good evening, this is Rahul Reddy. We're live here every Tuesday at 5 p.m. Central Time. Today we're going to discuss about do's and don'ts while your adjustment of status, also called as 485, is pending with USCIS. The prevailing wage, that's for filing the PERM labor certification. What's the validity period for it? And how does the mechanics of the prevailing wage works? We're going to discuss very thoroughly on that. Can multiple PERMs be filed on one prevailing wage? Let's say, for example, the prevailing wage has been used for one person. Can more persons use the same prevailing wage? Because it's taking 6 months nowadays. We're going to discuss about that. What if you got selected in the lottery, got your H-1B approved with October start date? Can you change the employer? What is the right time for you to change the employer? Right now, after October 1st or after October 15th? We're going to discuss about it. Emily, there are a lot of questions that are coming up right now. USCIS seems to be going at a very fast pace, wanting to approve the green cards of the 280,000. And what if my green card doesn't get approved by September 30th is a major question that is popping up with a lot of our clients. Now, let's address some of the issues that are there, Emily. My 485, my priority date is current. In EB2, I did interfile it. My file is still in Nebraska or Texas Service Center. Is there anything you can do or the clients can do to move it to USCIS?
To move it out of Texas or Nebraska, really the only thing we've seen is when the downgrade I-140 is still pending. That seems to keep it stuck there. So if you have already transferred your underlying basis back to EB2, but it's still stuck there because your EB3 I-140 petition is still pending, you could upgrade that to premium in order to be able to get that hopefully transferred out. But other than that, there's really nothing you can do to force them to move your case out to NBC.
Okay. So you said that if, let's say I have refiled EB2 application. I filed in October of 2020 EB3, and then later on I refiled the 485 application. And my EB3 is not approved. Still, I have to get the EB3 approved in the I-140 premium processing?
You don't have to. According to USCIS, they can adjudicate the EB2 on its own, but the EB3 I-140 may have a problem of keeping the EB2 case from getting adjudicated and even getting transferred to the other service center where you don't want it to be. So for that reason, even though you don't need the EB3 I-140, it is very helpful to get that approved.
And if you have not filed the medical reports though, we strongly suggest that you do file a medical right now. You do interfile. Now after interfiling also, sometimes they may still issue an RFE. We strongly recommend that after interfiling also, we want you to be prepared if there is an RFE to have your medicals submit in response to the RFE. Emily, what about 6 months rule after filing the 485J supplement? Let's say, for example, my priority date is 2014 January, and I upgraded it by filing the 485J supplement. And there is a 6 months rule. I should not leave. I don't know where they came up with. What should I do? What is the best method for that?
Yeah, I mean, the USCIS policy is that you can't port to a new employer until you've waited 180 days after you've interfiled to get to EB2. Have we seen them deny cases? No. Have we seen them enforce this rule? No. But you definitely need to contact an attorney to understand what the potential risks are if you end up having to move before that 180 days and what steps you should take.
Emily, my priority date is current. Everything is going good. Now I changed the company. Should I file the 485J supplement? Previously, you told that we recommended to file the 485J supplement. With the fast pace the USCIS is doing, do I need to file it right now? Should I wait for the RFE?
Yeah, at this point, we don't want to do anything that's going to slow down the process unnecessarily. So I'm leaning towards not filing it proactively and only submit it if you get an RFE asking for it or if you're called in for an interview.
I am thinking that not filing also, just like you, Emily, of not disturbing it. Maybe after September 30th, if my application is still pending, they should come back and listen to our YouTube, and then we may suggest something different. But with the fast pace at which they are approving right now, I don't want any disturbance other than approving my case, especially if my case in National Benefit Center. I don't want to do anything on that. Now, there comes the question, Emily. I filed my 485. My priority date is March 2014. I filed my 485 under EB3, and it's a straight EB3 application. As you know, Emily, the priority date is not current in EB3, but I had an approval with an EB2 with a previous company. Can we use that if the previous company is not cooperating? Can I still use that EB2 to upgrade it to EB2?
I think the technical answer is no, you shouldn't be able to do that because you're not with that employer, that job offer is not available to you anymore. But practically, USCIS is sending RFEs telling you to do it. They're sending an RFE saying, please submit a supplement J to confirm the job offer is still there. And by the way, we see you have this EB2 I-140 approval. Did you know you can also transfer the underlying basis by submitting the supplement J? So they kind of are giving the impression that you are allowed to do this. And some people have been responding with the old employer's I-140 case number, but the new employer completing the supplement J. And some people have been getting approvals.
Oh, have you done anything?
We have submitted some in that situation and are still waiting on the result of the ones that we've tested out. Of course, giving the client the information of the risks involved.
In my consultation, there are some lawyers who have done Emily, they have got the green card approval too. Now, there are some cases, Emily, where, let's say for example, EB3 is priority date is March of 2014. They may have an I-140 with previous company with EB2. Now they got their green card approval under EB2 right now. These people never submitted any 485J supplement. What should they do? And this is the most common thing that's happening right now.
Yeah, we were very concerned when we first started seeing this happening, thinking that, oh, they messed up and approved the application in EB2 when the person wasn't eligible. But we did contact USCIS on a couple of these cases, worked through the Ombudsman office, and they came back and said, no, this approval is valid. We have the authority to use that EB2 I-140, even if you didn't specifically request it. So I think it is a risk to try to go back and ask USCIS to revoke the approved green card. You're flagging something that maybe isn't an issue at all anyways. So I think I would talk to a lawyer that's familiar with these cases. And
then some of the lawyers are telling to file an I-90 to correct it. Some of the people are telling to do a motion to reopen. That means motion to reopen, telling them, hey, I don't want my green card, and cancel my green card and reopen my green card application. Do you suggest any of those things?
I don't at this time, based on the information we got. I will say I did file a motion in that exact situation because in my case, even the EB2 priority date was not current when this person got the green card approved. But while also filing the motion, we worked with the Ombudsman office, and the Ombudsman said, no, actually, even though the date isn't current in EB3 right now, we already assigned you a visa number when your EB3 date was current, and we just got around to approving it later. So even that one was not approved in error. So we may think that these things are being approved in error, but USCIS disagrees, and so why are we going to poke the bear and go back through this whole process again unnecessarily?
Emily, I want to move into the green card application, which starts with the PERM labor for most of the people for EB2 and EB3. The PERM prevailing wage used to take about a month or two. Right now it's taking 6 months. Can you explain if the prevailing wage has been issued, how long is it valid? Some people are telling it's valid for 1 year. Some people are telling it's valid for 90 days. What is it?
Yeah, and it's different for every case depending on when they issue it. So the general rule is a prevailing wage is almost always valid until June 30th of the following year. So if it was issued after July 1st, 2022, it will be valid till June 30th, 2023. Except that when you start getting too close to June 30th, when you're within 90 days of June 30th, then you're only going to get a prevailing wage that's valid for 90 days. And it does go beyond June 30th, but it's only 90 days. So you only get a 3-month window to complete all of your recruitment and file that application. But in fact, that's not the case. Even though the prevailing wage is valid for only 3 months, you're not always required to file the PERM within that 3-month period. It all depends on when the actual recruitment steps are done. So if you get your prevailing wage and it's only valid for 90 days, but you start the recruitment during that 90-day window, now you've extended the time that you have to file to 180 days from the day the first recruitment step was done. So I know there's a lot of different time periods there, but you do have to be careful of when your prevailing wage is required. You either have to file the application, the PERM application, or begin the recruitment before the prevailing wage expires.
Emily, can I file multiple, let's say the prevailing wage has been issued in July 20th, it's been issued. And your law firm has filed a PERM labor certification for that particular company for a group of 5 people, or let's say, can it be filed for 5 people with one prevailing wage?
Absolutely.
Let's say now you advertised in the newspaper, we got the prevailing wage, we advertised in the newspaper, you filed the PERM application somewhere in September, October of 2022. Can you reuse the prevailing wage again in November and December and do another advertisement?
Absolutely, as long as you do it while the prevailing wage is valid.
Can you do the same thing in March of 2023?
Mm-hmm.
Oh, wow.
Yeah, so of course the prevailing wage is specific to the job offer. So the work location has to be the same, the job has to be the same, title and duties, and the minimum requirements for the position have to be the same. And each person that's using that prevailing wage has to meet those minimum qualifications in order to get the labor and eventually the I-140 approved. But yeah, assuming that you have a group of people that all have the same background and all are the same job, same work location, all of that, you can absolutely use it.
For what about consulting company, Emily? They have multiple different locations. So do you mean to say their job location is different?
So for consulting companies, a lot of times they place workers all over the place and the job changes, it moves from place to place, where the company basically doesn't know exactly at any given time in the future where this person will be placed, but they always have contracts available and they'll be moving them around. We use the word unanticipated locations in our prevailing wage request as well as in the PERM and all of our recruitment. So if the job involves unanticipated locations, then all of the prevailing wage and recruitment is done from the company headquarters, even if the person might be working at a completely different location. So even if you have 5 different people that are working at 5 different locations, if they are all unanticipated locations in the prevailing wage and the advertisements, you can still use that same prevailing wage for all 5 people.
So in other words, in one prevailing wage, one consulting company can file that year-long, especially if they get it in July, all the way to June, and probably they can put an advertisement and extend it for 3 more months. So they can extend it all the way 15 months and keep filing hundreds of, if they fit into the same classification.
Yep.
That's very good to know. Companies can keep them ready, especially people who are waiting for prevailing wage and they're going out of status. So they need to contact these consulting companies that do this thing, especially if they fit into the job position for which they are at. Emily, with regards to, a lot of people are asking me this question. I got selected, I got the H-1B approval. Now the start date is October 1st. What is the right time for me to change the employer and retain my H-1B?
Yeah.
Can I apply for change of employer right now, or what do you suggest?
So the safest way to do this is to stick with your current employer and then file a transfer on October 1st, on or after October 1st. At that point, your H-1B has kicked in, and so it's just filed as a regular transfer. You're no longer subject to the cap and everything's fine. But of course, nobody lives in that perfect world where you're gonna stick with your employer for another 3 months and then change in October. So what happens if you want to change jobs now? In that situation, it all boils down to whether the current employer will withdraw your approved H-1B because you're leaving them now. If you can negotiate with them to say, hey, please don't withdraw until after October 1st, then you can change jobs now with your OPT, for example, and then wait till October 1st and file your transfer. As long as it's received on October 1st, you keep working for the new company the whole time. There's no gap in employment. So that would be the second safest way to do it, but you have to rely on your company not withdrawing the approved H-1B. Beyond that, it gets riskier if let's say you know the company is going to withdraw your H-1B, then I would say you're going to have to file your transfer now if you want any chance of saving that H-1B, but you're filing your transfer before it even takes effect. You risk USCIS denying it on the grounds that you actually have not been counted in the cap yet because your H-1B has not taken effect. We saw that several years ago with a rash of denials. Haven't really seen it so much since, and I'm not sure if it's because people are not filing that way anymore because of the denials, or if it's because USCIS is approving. I haven't seen any of those types of denials in probably the last 2-3 years, but there's always a risk that they could go back to that interpretation.
Let's go to questions and answers, simply, unless you have anything else.
Nope.
I have the question from Quota Ram. He's asking the question, does USCIS has enough employment visa applications pending with them to be approved where all 280,000 can be used? Yes. Yesterday, me and Emily has sat down together. We jotted down all the information that we got from the Department of Homeland Security, USCIS, and we figured out that at this point of time, they have 170,000 green cards pending as of June 30th or May 30th. We have a little bit debate about it, but 170,000 green cards are pending, and they have only 100,000 to be given, because based on the recent statistics that they released it by June 30th, they already approved 180,000, 177, 180,000 green cards. They already approved it, so they can only approve 100,000 more green cards. They do have 170,000 pending at this point of time. So yes, they have enough applications pending at this point of time.
LACBS says, once the case is in the National Benefit Center, how much time is it taking to approve the 485? So we have started tracking this to keep track of from the time of transfer, how long is it taking to get approved. I think the average is around 60 days. Right now, of course, it depends on if from the National Benefit Center it then gets transferred to a field office and whether there's an RFE involved from the field office or an interview, but on average 60 days.
Natural Yogi has this question. What can be expected at the port of entry for the advanced parole secondary inspection? They will just let you stay for about 10 minutes, look into their computers, and then let you get into the country. We have not seen anybody waiting there for more than 15 minutes yet. It's pretty quick there. They have two secondaries. One, they call it as soft secondary, where the advanced parole people will go in. And there is also called hard secondary. That's where they think so that some of the people are drug dealers or something like that. They put them in the hard secondary. You'll be put in the soft secondary. Along with you, like let's say for example, an American couple is adopting a Guatemalan orphan little girl or boys. I mean, those also will be sitting, those little boys and girls also. I mean, those children also will be sitting in that soft secondary, we call it as. So I have been, all the advanced parole people, if they are being taken into the secondary inspection, will 99% of the time will go to the soft secondary, especially if they are our audiences. It's 100% of the time that they go to a soft secondary.
Raul wants to know, for the green card to be approved, is it necessary for the petition or the application to be moved from the NBC to a field office? And are we seeing straight filing approvals? It's not necessary for it to move to a field office. We do see approvals coming straight from the National Benefit Center. I'm not sure if we've seen any from May or June timeframe. That's a little too early.
Are you speaking about National Benefit Center or through the Texas or Nebraska service?
National Benefit Center.
I do see the National Benefit Center directly coming without moving to the local.
Right, that's what I'm saying, but filed in May or June? I don't think so.
No,
maybe like March.
April 22nd is what the latest we have seen. If they are filed before April 15th or 22nd, I forgot it. We have seen some approvals that filed, but no, I haven't seen in May. Mm-hmm. Maybe next week we will see.
Yeah. Bob has an EB3 that was at the Nebraska Service Center. EB2 went to the National Benefit Center. Then a Tier 1 officer said that the EB3 was moved to NBC, which is good. But now they're saying today both are transferred to the Nebraska Service Center. Anything to worry? Well, I mean, it'll be processed eventually, but the worry is the time. I mean, the processing time.
When they transfer to Nebraska Service Center, they gave the reason for faster processing of your 485 application. We are moving it to Nebraska Service Center, which is not true. Okay, then what?
Yeah, I mean, that's the problem is the Nebraska Service Center is taking 10 times as long as the NBC to approve the case. So it doesn't mean your case is going to be denied or something because it went to the Nebraska Service Center. But the worry is the processing time, unfortunately. So hopefully they'll get moved back to National Benefit Center. If your EB3 I-140 is still pending, that's very likely the reason why it was transferred there. So if you upgrade that to premium and get it approved, then maybe they'll both be transferred back to NBC.
Question from Swati. How long it's taking for the PERM application? Her husband has filed a PERM application in December of 2021. It's about December right now. That's all I can say. There may be some cases that may be approved in the first week of January, but they're working on December 2021 right now.
Sonia says, what is the chance of getting the green card for an EB2 refile that was filed in May with the September 30th deadline? Well, we know USCIS said in a call that if you filed by early June, they intended to get those approved by September 30th. So you would fall under that situation, assuming this refile was based on an already approved I-140 at that point.
Venkat Reddy has this question. If it's a pending IPC, Indian Penal Code 498A section, he's speaking about dowry, a false one, which he's speaking about, will impact 485 if there is no arrest but active case in the court, though. I would definitely recommend that you contact a lawyer who's very proficient in it, especially if the lawyer has a lawyer in India, and here I am one of them. I'm a lawyer, licensed lawyer in India and here. It would be better that you contact a lawyer. There are many different ways how that can be handled. Venkat.
Ria says, do I have to submit any forms to USCIS if I plan to stay out of the U.S. for more than 6 months while the AOS is pending? So it depends on what your current status is. If you are in H or L status, you could leave and come back in H or L status without filing anything with USCIS, assuming you have the visa stamp, and that doesn't cause any problem for your 485. But if you're no longer in H or L status, or if you're in some other status, you need to have an advance parole, and you need to have it approved before you leave. That way you can come back, even if you stay for 6 months, you can come back anytime within the validity period of that advance parole, and you won't abandon your green card.
Manoj 485 interview has been already conducted. They said everything is good, but it's not approved. What can we do now? I would recommend you to contact the local congressman, though, because it will just alert them, hey, it's been like 60 days, you didn't do anything. So it will alert them to see if they're sleeping on it, they may wake up and file on that.
Volodymyr says the civil surgeon he went to missed the hepatitis B vaccination. It's a new requirement since May. He wants to know, is it possible if he missed something else, will the 485 be denied? So we don't see that happening. Typically, once the officer actually reviews the medical exam, they'll make sure everything is there. If they do see something missing, even if it's multiple things, they will put it all in an RFE and explain the situation and tell you to either go get the medical done again. Sometimes they mail the same medical back to you and tell you to go back to the doctor and get it corrected or whatever the issue is. But no, it's not going to be, we don't see straight denials in that situation. They give you a chance to submit a corrected one.
Emily, yesterday we have gone through a lot of numbers with regards to how the USCIS, how the Department of Homeland Security is approving the cases. Now we have the question from Jiten Bhagat, though. His priority date is 2018. Can he expect the priority date to be current in the next 5 years? I know in the last Sunday I did set that priority date is expected to move until about maybe end of 2015. Now, in light of the new data that the Department of Homeland Security has produced, in light of what the Department of USCIS has produced, in light of what the Department of State has produced the data, what do you think about the priority date movement?
Yeah, I think there are two things that could negatively impact the priority date movement. Number one is the number of family-based green cards that they're approving this year. So we looked at the data for Q1 and Q2, which is all we have available, and this is both Department of State and USCIS. And they seem to be on pace to where they were pre-COVID. So pre-COVID, there generally wasn't much family-based spillover because they were approving all those applications. So if they continue on this pace to where they use up all the family-based green cards, we won't have any spillover, so there's no extra green cards. The other potential problem that we have, looking at the numbers based on how many they've approved so far and how many pending applications they still had, it looks like they need to approve 100,000 more in the fourth quarter in order to use up this year's employment-based green cards, which they seem to be on pace to do. But if they do that, if they approve those 100,000, there may still be 70,000 more still pending, meaning they took in too many applications, they moved the date too far forward earlier this year. If that happens, then we're not going to see the same amount of movement in October or in 2023 fiscal year, because they already have 70,000 applications on file. That's going to use up half of the employment-based green cards we already get for next year.
And out of the 70,000, I would expect at least 50,000 are Indian nationals green card. So they may have an inventory of approximately 3 to 5 years of inventory. Plus, if your priority date is 2018, that's definitely doesn't seem to be very likely in the next 5 years if we were to believe in the numbers that they're providing. Unless there are two things that can happen. One, COVID can extend. Who knows? God, who expected COVID to come in? That's one thing. The second thing is that, and then they don't adjudicate the family immigration cases much. The second thing is the law may change, and that's another discussion. People are having some HR Bill 2022, I don't know which one they're telling about, and it's about CSPA. I mean, what are all the bills pending, Emily? It says NDAA 2023. Do you know what's going on it?
I believe it was moved forward to the floor of the House, so they made it out of committee, but it's still only in the House. And with the Senate, you're going to need, what, 10 Republican senators to get on board with any kind of normal bill in order to pass it and get past the filibuster. And I don't know if we have that. So it may very well pass the House. There is a lot of support for the legal dreamers and documented dreamers and whatever you want to call them, people that are aging out of the system even though they came here legally. So there is a lot of support for that, especially in the House, but we have to get it past the Senate. And I just don't know if that's going to happen, even though there's tons of support for it.
Yeah, we want you guys to be watchful on these, on our video shows. Right now, we have not drafted any letters to the congressman or ombudsman or the USCIS, especially on the legislation process. So we want you to watch very closely, because when it is the right time, when we think so that something is about to push past, though, we will tell you to push that at that point of time. Right now, we still want you, if you have not written letters to the congressman, ombudsman, and the USCIS director, please keep writing them to make sure that 280,000 green cards we have been given in this year. It looks though they are very likely to issue 280,000 or come very close to the 280,000 green cards, but you never know if they are going to continue the same pace or increase the pace to issue those things. So we want to keep you working on it. Now, from September onwards, now what about, Emily, you said if there are 70,000 green cards and out of them maybe 40 to 50,000 are Indian national green card, is there a chance for retrogression though? On the last Sunday in the TV, I said, no, it's going to move. Or what do you say with the new data?
Yeah, I don't think it'll retrogress, because I mean, that's the whole point of the filing date, is to avoid the retrogression.
I'll buy you some sweets on this, what you said now.
Oh gosh. Somebody had a question, I think it was a Krishna, about the Q2 data looking very disappointing, and do we think that USCIS is actually going to get to approve all of the applications, the 280,000 green cards this year? And I agree with you. The Q2 data, they actually approved fewer 485s and green cards at the consulate in employment base than they did in the first quarter, which is not a good sign. But what we do know, although we don't have Q3 data, that in that same format, we do have the Friday update from USCIS, I think it was 2 Fridays ago, where they said they have approved between both agencies, USCIS doing adjustment of status and Department of State doing the immigrant visas, 176,000.
Yeah.
So we had about 60 to 70,000 approved in Q1 and Q2 combined, And then they're saying by the end of Q3, they approved 176,000. That means that they approved 100,000 applications in Q3 alone. That's a good sign. If they do that one more time for Q4, they will get to the 280,000.
At the pace at which they're going through in the July approval rating, so I see that they're going at the pace to give the 280,000 green cards. Once case is an NBC, oh yeah, you already answered that question. Hold on, let's go to it.
Rajasekhar has a 2014 priority date, and he said after his I-140 was approved back then, the company name was changed. He went ahead and filed the 485 without the medicals and wanted to go ahead and submit those now, but the attorney is saying to hold off for 6 months due to the name change. And what would the impact be? In this situation, it sounds like it was probably more than just a name change. If it was just a name change, no problem at all. Your labor is valid, your I-140 is valid. All you have to do is submit proof of the name change. There's something that would have been filed with the state where the company is incorporated or doing business about the name change. So it's the exact same company that's filing and sponsoring, just a name change. No issues at all. The fact that they're saying maybe let's hold off for 6 months tells me maybe they're trying to utilize AC-21 and it's not a name change but an actual successor and interest situation. When it's a successor and interest and you have not filed the 485 yet, USCIS expects to file that the company will file an I-140 amendment to document that the new company qualifies as a successor in interest. So that's typically what we do in that situation, and you could have filed that with your 485. So not sure exactly what the situation is, but definitely something to, possibly get a second opinion on and make sure everything's fine with that application.
Ankit has this question. Can I reenter on advance parole if the 485 is approved? I went to India on vacation with AP, my GC is approved. Absolutely, you can enter an advance parole though. When you enter though, they may allow you to come on advance parole, or they may just allow you on, they call it as LPR, legal permanent resident, and allow you to come in. We have no problem, absolutely no problem in people entering on advance parole. Even for the people who have H1B and H4 stamping in the passport, if they get the green card, which we know that the H1, they're not on H1 and H4, but they do allow without any problem, absolutely no problem. The other thing, Ankit, what you can do is, if you or a friend or your cousin or somebody have access to a PO box, they can even mail. I wouldn't mail it your green card, but if somebody is traveling, you can hand it over the green card to them. They can give it to you in your home country, and you can still travel on that. That's legally allowed to have your green card carried by somebody else, only to transport it to you, not that they're using it. So that can be done. So we have seen all these kind of situations. People are emergency. They're calling me, oh, I've got my green card approved. I got stuck. Not a problem. No, never been any problem.
Abe says, any chance for a July 2022 interfile to get approved before September 30th, 2022? I think potentially. So number one, is your EB3 I-140 approved? Is your EB2 I-140 approved? And has your file been transferred to the National Benefits Center already? Have you gotten your 485J receipt notice yet? Have you submitted your medical already? If those things are all yes, I think it is a possibility. But if any one of those answers is no, it's either stuck at NSC or TSC, you don't have your medical submitted yet, or your I-140 is still pending or something like that. Those are all the things that are causing the delays.
Tapan Bora, his 485 green card has been approved 2 months back. Congrats. Now he didn't receive the green card and he's trying to raise a service request. It's not working. Tapan, there is something called InfoPass appointment. You can make an InfoPass appointment. You go there, they will stamp your passport saying you, Tapan, are a green card holder. And you can use that to travel outside the country and come back. Absolutely not a problem. You wait for 1 more month to see if the things don't work out though. If still you did not get the green card though, there is something called I-90. You can file it online. I mean, this I-90 thing, I would not recommend to go through a lawyer. This is not filing a green card. It's just like, give me my green card. I already got it. You can file it online, I-90 form. That's one thing that you can do. But I would recommend to wait for 3 months before you file it. But if you want to travel or you want to do something with your green card though, you absolutely can make an enforced appointment. They will go, they will verify it's you, Tapan or not, and they will stamp your passport, and that works as a green card. It's as equivalent as a green card it is.
Knowledge says I had an EB2 case filed, and the case has been transferred to the National Benefit Center. Got an RFE from the field office after that for the medical exam, and wants to know what are the chances I'm going to be interviewed. Is there a chance I can get this approved by September? So typically, if the case has been transferred to the field office and you're getting an RFE, that means they don't intend to interview you, because instead of interviewing you, instead of asking you to bring those documents to the interview, they're sending an RFE to let you mail them in. So it sounds like you're not going to get interviewed. They would have asked you to bring those to the interview instead, which means, yeah, there's a chance of getting it approved by September 30th, assuming you don't have a EB3 out there pending, and you already weren't any issues with your medical, and you responded to that RFE right away, and no issues with supplement J's pending, and all of that.
I say, Emily, when the prior date is current and they get an RFE for medicals, I tell them to buy a champagne and put in the refrigerator.
Yeah, it's about time to celebrate once you get that, for sure.
Questions with regards to the approvals of the green cards when the priority date is current. There are questions, a lot of questions coming, a lot of consultations coming. As Emily has pointed out, in cases where your priority date was ever current, even last year though. Remember Charlie said when he was in the Department of State, he retired, but before he retired, he said documentarily qualified. So there are some people who are documentarily qualified at that point of time. They have allocated the green card numbers for them, and now they are giving them the green card this year though. Or sometimes it may have been allocated in the month of December, January, when the prior date was current in EB3, and they're now given the green card in the month of July. And the USCIS is telling that they have an authority to do so. So I don't want to, if your green card gets approved, I don't want you guys panically, where the prior date is not current, I don't want you guys panically go back to USCIS and challenge their decision. As Emily has pointed out, it's not a right idea. Even if your lawyer is telling you to do that, though, we still recommend you not to do it. This is not an employer issue, this is an employee issue. Green card is yours, not your employer's. They may have helped you in getting the green card, but green card is yours. No lawyer can go and challenge your green card without your approval. I mean, he's your lawyer, he can't harm you. So if he's going against you saying that, oh, I have to do it because the employer told me to do it, I'm doing it, you need to have a private consultation. Don't go with that lawyer though. And he cannot violate. This is not an I-140 RFE. This is not a H-1B RFE. In cases like H-4, in cases like green card, you are the authority, not your employer. Once your green card is given, you are more or less independent. You don't have to listen to your company's lawyer. You don't have to listen to your company.
All right. I wanted to talk a little bit about the timeline for the PERM process because it's taking longer and longer these days, so people are aware of what to expect with that situation. The first thing is you've got to get the prevailing wage submitted, and those are taking 6 months to process, whereas before it was maybe a month, maybe 2-3 months. So that's added a huge waiting period to getting the 485 ready to file. I'm sorry, the labor certification ready to file. On top of that, once you get the prevailing wage, or maybe sometimes while you're waiting for the prevailing wage, the company has to go through the whole recruitment process. That involves newspaper ads, job orders. We've had problems with the job order websites for several of the states recently, so some job orders couldn't get posted, which delays things. The job order has to be posted for 30 days, and then you can't file the application for at least the next 30 days after the job order is done. Also have to do a notice of filing that gets posted at the work location for 10 business days, and then you have to wait 30 days after that before you can file. So those are some of the things that take the longest to do. And because of that, once the recruitment steps are started, it can take up to 6 months to actually file the application, the PERM application. So that means you're looking at potentially 6 months to get the prevailing wage. And of course, that's not counting the time it takes to prepare the prevailing wage for submitting. That involves the employer working with their attorney in order to develop the job description, exactly how it's going to appear in the advertisement, what are the minimum requirements for the position, minimum education, minimum experience, are there any special skills or licenses or certifications required, what are the work locations. All of that has to be nailed down before the prevailing wage can be submitted. Gathering your documents, making sure you can get the experience letters, making sure we have education evaluation, if that's needed for a foreign degree. So there's some prep work even before submitting the prevailing wage. So plan on probably a month just to get the prevailing wage submitted, 6 months to get that, another 6 months to do the recruitment, and then you can finally file. We're already at the 1 year mark before you can file the PERM. PERM processing time is 6 to 7 months right now. So that's 18 months to get your PERM approved. And then you have to file your I-140 petition. Once you get your I-140 petition approved, that is what allows you to get those 3-year extensions beyond the 6-year limit of your H-1B, assuming you're from a country that has a backlogged priority date. So that basically means 18 to 24 months to get from the part of starting your PERM to approved I-140. So please remember that when your H-1B, you're looking at when is your 6-year limit, you really should be starting this process no later than the 4th year of your H-1B. No longer can you wait until your 5th year, otherwise you're going to run out of time. Sriji has this question.
Why I-485 applications are going from NBC to Texas? I have no clue. No clue. They should not be, because they said the Texas and Nebraska Service Center are now no longer adjudicate the 485 applications, except in cases where they already started adjudicating the applications, though. We don't see a reason why they are sending it there. There are some common things that I can tell where they are going is, let's say for example, you filed an EB3 485 application and now you refile the 485 application in EB2 and your EB3 I-140 is still pending though. We are noticing that they are moving your 485 off the EB2 application to Texas or Nebraska though. That's the reason why we are telling everybody that if your I-140 is pending, even though USCIS in their frequently asked question is telling you that we don't require that EB2 to be EB3 to be approved for you to be granted, we are telling people go ahead and file the premium processing, get an I-140 approval. A question from Meena Ram. Priority date is September 2013, downgraded to EB3 and received EAD and AP, interfiled in June, nice, and received, fees waived yesterday. What next? When will I get the green card? Meena, the most probable thing what will happen to you right now is that your case will be moved to the National Benefit Center. And from then on, either they will adjudicate the case or they will move it to the district office. According to Emily's blog, which is in immigrationgirl.com, which she publishes the data from one of the lawyer's desk, which happens to be my desk, is there that she's telling it's taking approximately 60 days on an average on the cases that she only targeting the cases that get approved though, approximately taking 60 days for them once it moves to the National Benefit Center. Now, not every case will take 60 days. Some may take only 30 days, some may take only 90 days. On an average, it's taking 60 days. So that's the next process for you. Hopefully so. So you have done everything perfectly right now. Nothing can be done. Let's hope so. Things will work out very good for you.
I wanted to go back to kind of the do's and don'ts of the 485 when it's pending. What are the things you can do to avoid extra delays? What are the things that you shouldn't be doing? So number one, what we talked about was making sure all of your I-140s are approved. So even though you don't have to have the EB3 I-140 approved if you're transferring back to an EB2 approval, make sure you get that approved anyways, because it's going to keep your case pending at Nebraska or Texas, or cause, if you refile, cause your refiled 485 to get transferred to Nebraska or Texas. So we want to do everything we can to get out of Nebraska or Texas. Getting the I-140s approved is a great way to do that. Interfiling your medicals if you filed without those, that is still an option. Now I know USCIS keeps coming out saying, please don't do it, don't do it. But they are accepting them, and it does speed up the process because you're avoiding that RFE for the medical exam. Now, if you're going to interfile, what we would recommend is get multiple copies, multiple originals in different sealed envelopes of the medical, because if you interfile and it somehow doesn't make it into the file, you'll have the other one and can bring it to the interview or submit it in an RFE without having to go back to the doctor. So that's an option. And of course, if your EB2 date is current, consider interfiling to get back into EB2, even potentially if you're no longer with that EB2 employer, or refiling your 485 if that employer is still, has that job offer available. Those are some of the things that you can do to try to get this going faster.
Pankaj Sharma, his green card, the main applicant green card got approved, but the dependent is still pending, filed 6 months ago. There's nothing you can do because you can't raise a service request. They'll tell you it is within the time limit, so they're not going to do anything. Unfortunately, if you have if you have done all the things for medical and everything, there's nothing else can be done at this point of time.
Pavan mentions, filing the 485 in May and the cases at the NBC, and people that have filed after him based on, different websites and forums where people are reporting this. People that filed after are still getting approved, and why is his not getting approved? There is no first in, first out with these applications.
I was looking at one other thing, Emily. One question was asking, is it the priority date? Is it the filing date? Is it the transfer date? Which one they are prioritizing to give the green card approval?
Well, if you ask USCIS, they say we are prioritizing all of them, which means they're prioritizing none of them. There is no order. It's just whatever they get their hands on where documents are there. No rhyme or reason to it, unfortunately. That's why, we're seeing people that filed in 2022 getting approvals and people that filed in 2020 still pending. They're definitely not following first in, first out.
Is EB3 I-140 should be approved to move the case from SRC to NBC? Yes, this is the most common thing that we are noticing it. If the EB3 I-140 is still pending, they are not moving it to National Benefit Center. There may be one or two rare cases, but most of the cases, that's a report that we have based on the YouTube, Facebook, and other media that we have, TV Asia, and our own clients, our consultations that we have. That's the report that we have.
Srenuaz says the 485 is still at Nebraska, filed in October 2020, requested the transfer of the underlying basis in February, and then the company was acquired by another company and they filed another supplement J in May and wants to know when it will be adjudicated. I think the answer to that really depends on if and when they decide to transfer out of Nebraska and get it to the National Benefit Center. If it stays in Nebraska, we're just barely starting to see some approvals from October 2020 out of Nebraska. So it could be months still. It's a snail's pace there.
I haven't seen in the past 2 months.
Yeah.
Anything. Chandu has this question. His case has been moved to San Antonio, which is not his local field office. Is it normal, Emily? Is it a good sign?
Yes and yes. We are seeing many applications transferred to field offices nowhere near where you live. And that's because they're utilizing the field offices that have the capacity to take more applications. So that's a good thing generally. And the fact that they did send it to a field office that you're not near means they don't plan on interviewing you. So that also saves time as well.
Gadgets World has this question: as minor children got a biometric notice after the green cards are approved. Is it normal? What do we do about this biometrics? First of all, biometrics are only required for the children who are 14 or above, Emily, and that's why we pay the fees. But I've noticed recently, even under 14 people, somewhere like 10 to 14 people, they're getting the biometrics information though. Maybe it's a good sign. They don't need to do the biometric after they get the green card when they turn 14. This guy got the biometrics after they got the green card. Our suggestion will be that please go to the biometrics. Don't play with them. Just go with the biometrics. Don't tell them you got the green card or anything. Just show them, here's the biometrics. Just go and give it and come back.
Srilatha says we downgraded in October 2020 and then changed jobs and filed the supplement J. Can we interfile now with the previous employer's EB2 I-140? So again, I think the technical answer is no, but the practical answer is it's working. So if your new employer is willing to submit a new supplement J that references your old EB2 I-140, making it clear that they're choosing box 1B for portability and they're providing all of the correct job details for the current job, it's up to USCIS to decide whether they'll accept that transfer of the underlying basis. The worst thing that can happen is they say, nope, you don't qualify, but you're still in EB3 and everything's fine in EB3. So I don't see any harm in doing it. We have been seeing approvals in cases where it has been done, even though it's, based on their own policy, it shouldn't be allowed.
Emily, I have a couple of questions for you, Newton. I filed my 485 in EB3. My priority date is September 2014. My old company has an EB2 I-140 approval. Can they file an upgrade from EB3 to EB2? He's not working for the previous company.
So they...
His priority date is September 2014 and filed straight EB3 application. His previous company has an EB2 I-140 approval. Can the previous company file a 485J supplement and upgrade it to EB2?
So that seems to be working, I think.
Yeah, I mean, the previous company is willing to cooperate. Then yes, absolutely. Yeah.
Yeah, in that situation where the previous company is saying, yes, we're still offering you that job, no risk at all.
No risk at all. It's absolutely straightforward. But if they are not doing it, I would recommend there are still ways around it to use those. If they are cooperating, if they are going to sign the 485J supplement, if they are telling that the job offer is still open, go ahead. It's a slam dunk. Nothing to look into. But if they are not cooperating, if the EB2 I-140 is still approved and not withdrawn, you may want to consult a lawyer because there are still ways to use the EB2 I-140 from previous company. Another question for you, Emily. Deepak is asking this question. He filed a PERM, but it's taking a long time. His priority date is current. He has I-140 approval with the X company. Can he continue working with the current company and the previous company file a 485 application?
Yeah, absolutely. Remember, this whole process is not based on your current job. It's based on the future job you'll take when you get your green card. So if your old employer is still offering you that job and you still intend to take that job, absolutely. You can file your 485, submit a supplement J from your old employer that references that EB2 I-140 approval and all of the details on that labor certification. No issues with that whatsoever.
Emily, the question is, if company B, I'm working with company A, company B has filed a transfer of H-1B application. While that is going on, I didn't join company B. Can company A file a H-1B extension without causing any problem?
Yeah, absolutely, they can do that. If you haven't joined the other company, you're still maintaining your status with the first company, you can do that. The fact that you filed a transfer means nothing. Because you haven't joined that company, you're not utilizing it. It becomes what we call a dormant H-1B at that point. And in the future, say you get your H-1B extension with company A and you then decide to move to company B, that H-1B is still valid and can be used as long as the company never withdrew it. So no problem with that at all.
Albrecht has this question: how long it's taking for the processing time for naturalization? Depending on the district where you are in, anywhere between 5 months to about 16 months is the processing time for the naturalization applications.
Mohit says, can someone interfile the 485J to EB2 if the EB3 was filed as an amendment? I think that's where it gets a little tricky, because the way USCIS looks at it, although this isn't written down anywhere, when you file an I-140 amendment, they treat it as if the original I-140 no longer exists. So I don't think it's as simple as just filing an interfile to the EB2, because they could say your EB2 doesn't exist anymore. You could still proceed by filing another I-140 in EB2 using that same labor certification that you've now used 3 times, And then in that I-140 petition, you can request them to transfer the underlying basis. I've not been seeing that working. So you can then upgrade that to premium, get it approved, and then submit the 485J to transfer the underlying basis to the new EB2 approval.
Anything else, Emily, before we close?
Oh, didn't realize it was time yet. I think we're all out of time. Thank you for joining us. Make sure you subscribe to our newsletter at rnlawgroup.com. We do send that out every Wednesday. That has lots of great updates, articles from our office. And you can also subscribe to immigrationgirl.com to keep track of all the latest with all these AOS processing times.
Especially if you want to see the AOS, how long it's taking for the applications been filed, please log into Immigration Girl, and there's an article. Emily keeps updating every week with the approvals from our office. Thank you.